Hello, everyone. Here comes to part 2 of today's presentation. I would like to talk about the anti-money laundering and counter-terrorist financing requirements for licensed moneylenders. To begin with, let's take a look at the relevant legislation and guidelines that are relevant to licensed moneylenders. First of all, that is our AML guideline. The guideline on compliance of anti-money laundering and counter-terrorist financing requirements for licensed moneylenders. The guidelines will be revised from time to time, and it is last revised in June this year. The guideline was promulgated with reference to the requirements set out in the AML, and its purpose is to give guidance to licensees for the implementation of effective measures to mitigate the risk of money laundering and terrorist financing. Even though it is just a guideline, non-compliance may cast doubt on whether the licensee is fit and proper to carry on business as a moneylender, and whether its officers are fit and proper to be associated with the business of money lending. The other relevant legislation relating to money laundering and terrorist financing, financial sanctions, and financing of proliferation weapon of mass destruction are as follows. You may take a look at this, and we'll also go into more details later today. As I've just mentioned, our guideline was last revised this year in June, and it was because of the amendment to the AML. In June 2002, the government has gazetted the amendment bill introducing changes to the AML. The major amendments include introducing a licensing regime for virtual asset service provider and a registration regime for dealers in precious metals and stones, imposing the statutory anti-money laundering and counter-terrorist financing obligations on these two sectors. The opportunity was also taken to address a number of miscellaneous and technical issues under AML, which have been identified in mutual evaluation and other FATF contexts, such as to better align the definition of beneficial owner in relation to a trust under AML with that of controlling person under the Inland Revenue Ordinance, and by clarifying that where a trust is concerned, it includes a trustee, beneficiaries, and classes of beneficiaries. Also amending the technical definition of politically exposed person, that is the PEP, in accordance with the FATF requirements. The new PEP definition will include PEPs from other parts of China outside Hong Kong, and introducing the concept of former PEP, but allowing more flexibility in the treatment of former PEPs who are no longer entrusted with a prominent public function, so licensee can take a risk-sensitive approach in determining the degree of CDD to be taken in respect of the former PEPs. And lastly, allowing the engagement of digital identification system to assist the conduct of customer due diligence for non-face-to-face situations. For the effective dates, registration regime for dealers in precious metals and stone was effective in April this year. And for the licensing regime for virtual asset service provider and all the miscellaneous and technical amendments that I've just mentioned are in June this year. And we have already reflected these amendments in the updated guideline, which was revised in June this year. So you have to pay attention to the amendment in the guideline. In general, licensees are required to take all reasonable measures to mitigate the risk of money laundering and terrorist financing, and also to ensure that the requirements under AML are complied with. To fulfill these obligations, licensees must assess the money laundering and terrorist financing risk of their business, develop and implement policies, procedures, and control on the following aspects, including the CDD measures, ongoing monitoring of customers, suspicious transaction reporting, record keeping, staff training, and independent audit functions. And I will talk about this one by one in the following slides. First of all, it is the CDD measures. What are CDD measures? As you can take a look at this. Firstly, you have to identify customers and verify the customer's identity. And if there is beneficial owner behind the customer, you have also identified the beneficial owner and to take reasonable measures to verify the beneficial owner's identity. And you have to obtain information on the purpose of intended nature of the business relationship if a business relationship is to be established. If someone proposes to act on behalf of the customer, for example, if the customer is a company and the director proposes to act on behalf of the company, then in addition to identifying and verifying the company's identity, you also have to identify the director, the identity of the director, and to take reasonable measures to verify the director's identity. You also have to verify the director's authority to act on behalf of the customer. That is, maybe you can ask for a board resolution. For the identification and verification of different types of customer, we have 4 appendix in our guideline, which you can make reference to. If the customer is an individual, then you can refer to Appendix A of our guideline. For corporation, that is Appendix B. Partnership or unincorporated body, that is Appendix C. And for trust, you can take a look at Appendix D. You can collect the documents and information that is required in accordance with our appendix. And now, I would like to introduce the definition of beneficial owner in relation to a trust. As you remember, I have just said, the AML has been revised to revise the definition of beneficial owner. And let's take a look at the definition in the ordinance. AML defines a beneficial owner in relation to a trust as a beneficiary or a class of beneficiaries of the trust entitled to a vested interest in the trust property, whether the interest is in possession or in remainder or reversion, and whether it is divisible or not. Also include the settlor of the trust, the trustee, a protector or enforcer of the trust, or an individual who has ultimate control over the trust. Before the amendment, the old definition of beneficial owner in relation to a trust does not include the trustee of the trust. And also, the definition is an individual who is interested in more than 25% of the capital of the trust. After amending the definition, the threshold of 25% has been removed, and also it clarified that a beneficiary or a class of beneficiary are also defined as the beneficial owner in relation to a trust. And now it comes to the part when to carry out CDD. Firstly, you have to, before establishing a business relationship with the customer to carry out the CDD, please remember that it is before establishing the relationship, but not after. Or you can, before carrying out an occasional transaction involving 120,000 Hong Kong dollars or above. Or if you suspect that this customer or the customer's account is involved in money laundering and terrorist financing. Or if you doubt the veracity or adequacy of the information previously obtained during the CDD process. If the above requirements are not complied with, the licensee must not establish the business relationship or carry out the occasional transaction with that customer. And if a business relationship has already been established, licensee must terminate it as soon as reasonably practicable. There is one reminder for you guys is that the definition of business relationship and occasional transaction are actually set out in Section 1 of Part 1 of Schedule 2 to the AML. The definition of business relationship means a business, professional, or commercial relationship between a licensee and a person that has an element of duration, or at least at the time when the person first contacts the licensee as a potential customer, the licensee expects the relationship to have an element of duration. And the definition for occasional transaction is that a transaction between a licensee and a customer who does not have a business relationship with the licensee. One reminder for licensee is that insofar as occasional transactions are concerned, licensees should be vigilant to the possibility that a series of linked occasional transactions could actually meet or exceed the CDD threshold of 120,000 Hong Kong dollars. If licensee become aware that these thresholds are reached or exceeded, full CDD procedures must be applied. The factors linking occasional transactions are inherent in the characteristic of the transactions. For example, where several payments are made to the same recipient from one or more sources over a short period of time, and where a customer regularly transfers funds to one or more destinations. In determining whether the transactions are in fact linked, licensees should consider these factors against the time frame within which the transactions are conducted. Other than conducting the CDD measures by licensees themselves, licensee actually can carry out CDD measures by means of an intermediary. However, licensee have to make sure that you have already obtained the written consent of the intermediary, and also that licensees are satisfied that the intermediary will, on request, provide a copy of any document or record or data information obtained in the course of carrying out the CDD measures without delay. However, the ultimate responsibility for ensuring the CDD requirements are met remained with the licensees. So who can be the intermediaries that licensees can engage for carrying out the CDD measures? Let's take a look at this slide. Intermediaries in Hong Kong, they are allowed under the AML and the guideline belongs to two main big categories. First of all is the financial institutions and also the professional intermediaries. For financial institutions, it includes authorized institution, licensed corporation, authorized insurer, individual insurance agent, insurance agency, and insurance broker company. For professionals, include the accounting professional, estate agent, legal professional, and a TCSP licensee. Other than carrying out the CDD measures before entering into the business relationship, licensee actually also have some continuing obligations. Licensee should continuously monitor the business relationship with the customer by reviewing from time to time all the data information collected during the CDD process to ensure that they are relevant and up to date. Also, licensee should scrutinize the transaction to ensure that they are consistent with the licensee's knowledge about the customer and its business, risk profile, and source of funds. Lastly, a licensee also have to identify transactions that are complex, unusually large in amount, or of an unusual pattern that have no apparent economic or lawful purpose, and examine these background and purposes and set out the findings in writing. For the ongoing monitoring, a licensee should adopt a risk-based approach. That means the extent should be commensurate with the risk profile of that customer. Higher risk business relationships require more frequent and intensive monitoring, and also a licensee have to carry out additional measures when monitoring business relationship which pose a higher risk. In this slide, I'm going to introduce an offense called tipping off. It is an offense for a person knowing or suspecting that a disclosure has been made to JFIU if he or she discloses to any person any matter that is likely to prejudice any investigation which might be conducted following the disclosure. However, making inquiries to customers, if conducted properly and in good faith, will not constitute tipping off. If a licensee reasonably believes that continue to perform the CDD process will tip off the customer, the licensee may stop pursuing the process and document the basis for its assessment and file a suspicious transaction report to the JFIU. We have introduced CDD measures in our previous slide. And this slide, we're going to talk about the additional measures or enhanced customer due diligence, that is the EDD. For some situations where higher risk is involved, a licensee may have to apply additional measures or EDD. Such situations include where customers are not physically present for identification purposes. If a customer is not physically present for identification purpose, licensee will generally not be able to determine whether the documentary evidence of identity actually relates to that customer that they are dealing with, and therefore the risk in this respect increases. Or if the customer or its beneficial owner is a PEP. Of course, also in any situation specified by the registrar in a notice given to the licensee. So, for cases where customers are not physically present for identification purposes, the licensee should at least conduct one of the following measures. Firstly, is to verify the customer's identity on the basis of some other documents that have not been previously used for the purpose of verification, or for information relating to that customer which has already been obtained, to take supplementary measures to verify that information, or ensuring that the first payment made into the customer's account is carried out through an account opened in the customer's name with an authorized institution or a bank operating in an equivalent jurisdiction that has measures in place to ensure compliance with requirements similar to those imposed under Schedule 2 to the AML, and is supervised for compliance with those requirements by a banking regulator in that jurisdiction. But there is one exception to the above. If licensee verified the identity of a customer on the basis of data or information provided by a recognized digital identification system, licensee is not required to carry out any of the above additional measures or the enhanced ongoing monitoring measures. And now for politically exposed person, as you remember, AML has amended the definition of PEP. Let's take a look at the definition in the ordinance. Politically exposed person means any individual who is or has been entrusted with a prominent public function in a place outside Hong Kong, and this includes a head of state, head of government, senior politician, senior government judicial or military official, senior executive of a state-owned corporation, and an important political party official, but does not include a middle-ranking or more junior official of any of the categories above. It also includes the spouse or partner, a child or a parent of the PEP, or a spouse or a partner of a child of such PEP. It also includes a close associate of the PEP. For former PEP, it means any individual who, being a politically exposed person, has been but is no longer entrusted with a prominent public function in a place outside Hong Kong, and also include the spouse, partner, child, or a parent of the former PEP, or a spouse or partner of a child of such former PEP, or the close associate of such former PEP. Before the amendment of the AML, the definition of PEP is actually any individual entrusted with a prominent public function in a place outside the PRC. So let's pay attention to the new definition now. You may notice that there are actually 4 different types of PEP in our guidelines, namely a non-Hong Kong PEP, a former non-Hong Kong PEP, a Hong Kong PEP, and an international organization PEP. A non-Hong Kong PEP has the same definition as the definition of PEP in AML. A former non-Hong Kong PEP also shares the same definition of former PEP in AML because they are all referring to non-Hong Kong. For a Hong Kong PEP and an international organization PEP, the definitions are set out in our guideline, and you may take a look at that. For the applicable EDD measures for different types of PEP, they vary slightly. And so you may refer to the relevant paragraphs in our guidelines for the details. Okay, now for treatment of former PEP, again, licensees should take the risk-based approach. And if the customer or the beneficial owner is a former PEP and the licensee, after assessment, are in the opinion that the former PEP does not represent a high risk of money laundering and terrorist financing, then the licensee may decide not to apply or continue to apply the EDD measures or enhance the ongoing monitoring. So to allow more flexibility for licensee to determine the treatment for former PEPs. And for record-keeping obligations, how long should the records be kept and what records should be kept? As shown in this table, for each customer, you need to keep all the records throughout the continuance of the business relationship. And even after the business relationship ends, you should keep the record for at least 5 years. For occasional transactions, that is at least 5 years, beginning on the date on which the occasional transaction is completed. For documents that should be kept, they are the documents or record obtained by the licensee in the course of CDD for the purpose of identifying and verifying the identity of customer, the beneficial owner, or person with authority to act, and other connected parties. Also, the documents that are relevant to the purpose and intended nature of the business relationship. And those files relating to customer's business relationship and business correspondence with the customer and the beneficial owner should also be kept. In relation to each transaction, that is 5 years at least after the completion of the transaction, whether or not the business relationship ends during that period. For the records to be kept, they are the transaction documents, which shows the identity of parties to the transaction, nature and date of the transaction, type and amount of currency involved, the origin of funds, forms of funds offered and withdrawn, etc. You may take a look at this table for more details. For the documents to be kept, it is not necessary that you keep the original or a copy of such document or record. A database of a computer is also acceptable. For financial sanctions, the United Nations Sanctions Ordinance made an offense that any person to make available or deal with the economic access of any individual or entity designated by the UN Security Council. For terrorist financing, the United Nations Anti-Terrorism Measures Ordinance also criminalizes the provision or collection of property and making any property or financial-related services available to terrorists or terrorist associates. Therefore, licensees are strongly reminded that not to have any business relationship with any sanctioned individuals and entities or any terrorist or terrorist associate. For details, you may refer to Chapter 8 of our guideline. How to ensure that the licensee will not be dealing with sanctioned individuals or terrorists. The gist is licensee must have an appropriate system so that they can conduct name checks against the relevant list. Before establishing the relationship, licensee should screen customers against the current list. And if subsequently the list have been updated, licensee should screen their entire client base against the new list. The list of sanctioned persons and entities and lists of persons designated as terrorists and terrorist associate are available at the website of the company's registry. For counter-financing of proliferation of weapons of mass destruction, the United Nations sanction regulations there are two. One is in relation to the Democratic People's Republic of Korea, and another one is for Iran. Under Section 4 of the Weapons of Mass Destruction, Control of Provision of Services Ordinance, it is an offense for a person to provide any services where he or she believes or suspects on reasonable grounds that those services may be connected to weapon of mass destruction proliferation. Later this afternoon, Mr. Tan from CEDB will have more details on the proliferation financing and risk assessment to give more detail to you. For reporting of suspicious transactions, the relevant ordinance are set out in this slide. So in cases where suspicions of money laundering, terrorist financing, financing of proliferation of weapons of mass destruction, and sanctions violations, licensees should make a report to JFIU. Details can be referred to in Chapter 7 of our guideline. And Ms. Kwai from JFIU will also talk about the money laundering, terrorist financing methods, and STR reporting in the later section. For staff training is actually a very important element for an effective system to prevent and detect the money laundering and terrorist financing activities. Effective implementation of the training includes that staff should be trained in accordance with their particular roles with respect to the AML and CTF. Licensees should also implement and clear and well-articulated policies so that they can ensure relevant staff receive the adequate training. Training methods and assessment should be determined in accordance with the size and complexity of the licensee's business and the type and level of money laundering and terrorist financing risk. For frequency of the training, it should be sufficient to maintain the relevant staff to have sufficient knowledge and competence. Licensees should be reminded that record of staff's training should be kept for at least 3 years, and it is the record for each staff and have to include the date and type of training received by each of them. Lastly, it is the independent audit function that licensees should establish. Such function should have a direct line of communication to the licensee's senior management and should also have sufficient expertise and resources to enable it to carry out its responsibilities. The audit function should be regularly reviewed. The review should include the adequacy of licensee's system, the risk assessment framework, and application of the risk-based approach, effectiveness of suspicious transaction reporting systems, effectiveness of compliance functions, and also the level of awareness of staff having the relevant responsibilities. Frequency and extent of the review should be commensurate with the nature, size, and complexity of the licensee's business and also the risk involved. That's the end for my presentation. Thank you.